Life after decree. Modified child support or custody. Life after divorce rarely stays static. Families face new jobs, moves or evolving needs, and a decree that once worked may suddenly feel outdated. New York law recognizes this reality, so you don't have to be bound by an arrangement that no longer serves your children. Working with a New York City divorce mediation lawyer allows parents to adjust an order through cooperation rather than conflict. New York courts prize stability. A parent seeking modification must show that circumstances have changed significantly and that the proposed adjustment promotes the child's best interests. In custody cases, judges look for a substantial change, such as a relocation that makes the schedule impractical, new evidence of neglect or domestic violence, substance abuse or ongoing interference with visitation, and then decide whether the change advances the child's welfare. For child support, orders may be recalculated if unforeseen events like job loss or unexpected medical bills occur, if 3 years have passed since the last order, or if a parent's income shifts by at least 15%. Importantly, any modification takes effect only from the filing date, so prompt action prevents arrears. New York requirements. Because courts emphasize continuity, the burden is on the parent seeking a change. Moving far away, serious health or safety concerns, or repeated denial of visitation may all constitute a significant shift. Once a judge agrees that circumstances have evolved, they weigh factors like each parent's ability to provide a stable home, the child's emotional and developmental needs, and whether each parent supports a positive relationship with the other. For child support, judges review the financial threshold and will not reduce payments for voluntary income loss. Choosing a path. Parents who have a legal basis for modification must decide how to proceed. Returning to court sets a combative tone from the moment one parent serves the petition. The process involves exchanging financial disclosures, making multiple court appearances, and sometimes going through a hearing or trial. It is expensive because each parent typically hires a separate attorney. It can take months or even years, and the judge, who has only a limited view of your family, dictates the outcome. Everything becomes a matter of public record. Litigation is sometimes necessary but often intensifies conflict and drains resources that would be better spent supporting the children. Mediation offers a collaborative and confidential alternative. With the help of a neutral mediator, parents work together to craft solutions tailored to their family. Mediation empowers parents to stay in control of the outcome, share the cost of one mediator, resolve issues in a few sessions, and keep personal details private. Because the process focuses on cooperation, it preserves the co-parenting relationship and produces durable agreements. The mediation process. Post-divorce mediation unfolds in stages. In the first session, the mediator explains their neutral role and stresses confidentiality. Both parents share documents like pay stubs, tax returns, and copies of the existing order so everyone has accurate information. Next, the mediator helps identify the issues, whether revising the parenting schedule, recalculating support, or allocating new expenses, and encourages creative problem-solving. The negotiation phase follows, with the mediator guiding balanced discussions and testing ideas against how a court might view them. When parents reach consensus, the mediator drafts a detailed agreement. Each parent should review it with an independent lawyer to ensure it reflects the negotiated outcome and protects their rights. Once signed and submitted, a judge reviews the document for compliance with New York law and incorporates it into a new, binding order. This process gives families the enforceability of a court order without the antagonism of litigation. Mediation does not require you to sacrifice your rights. Instead, it allows you to shape your family's future while avoiding the delays, costs, and adversarial nature of court proceedings. A knowledgeable attorney can help you determine whether mediation or litigation better suits your circumstances. At the law office of Besinque, a compassionate law firm guides families through post-divorce modifications with clarity and respect. If you're ready to explore your options, contact the law firm at 929-251-4477 or visit 115 West 25th Street, 4th floor, New York, New York, 10001.